सर आगे जजमेंट की प्रोसेस
Pronouncement of judgment WPC 1966/2018.
Petition dismissed.
I will give all of 1 week's time.
Okay, both sides are represented on the prayer made by Mr. R.P. Sharma, on a senior counsel, assisted by Ms. T. Song, the counsel for the petition. Matter stands adjourned today. Released after ensuing winter vacation.
May I please, Lordship? My Lord, item 40, the petitioner is behind the bar since last 3 months, 11 days. Only due to delay, your Lordship expressed displeasure and kept some time, so it may kindly be taken after motion matters.
Okay.
Highly obliged.
Oh, this is upgraded, man. It will be called up now.
My Lord?
We are accepting your request. We are upgrading it now.
Oh,
We'll take
highly
it up
obliged.
immediately.
Much more obliged.
Item 48 also, my lord.
48.
Yes, my lord. He is in attention, my lord. Supplementary discussion.
48 is admission.
Yes, my lord.
We'll call it in the admission column.
Yes, sir.
At
At 2 p.m., my lord.
No, I'm saying about 2 p.m., but it will probably called. We'll call it
May it please, Your Lordship. My Lord, I beg to mention item number 19, Your Lordship.
19.
Item number 19, Your Lordship. Although it is a Your Lordship, long pending matter, Your Lordship. Today I have some difficulty, Your Lordship. Your Lordship allowed after the vacation.
Okay, both sides represented. After vacation, is paid for by the counsel of the petitioner. Okay.
Lordship, deep oblige, Your Lordship.
May I please, lordship? Lordship, I beg to mention item number 33, lordship. This is lordship in terms of ex parte order, lordship. The petitioner is in detention camp, lordship, since 2nd of September, lordship. And this matter may be updated, lordship.
Okay, we'll try to. Later note.
Lordship.
how
May
Yes.
next. May it please, Your Lordship. Lordship, I beg to, my lord, pray for, my lord, upgradation of item number 31, my lord. I'm being led by Mr. M.K. Chaudhary, my lord. He has asked me to request, Your Lordship, that matter will be taken up at 2 p.m., my lord. Some urgency is there, my lord. It's, my lord,
We'll see. We'll try to take it up,
At
but
2
we'll take
PM.
up this bail matters and all, then thereafter only.
my lord, if possible,
People who are in detention will take it up first, then we'll take it up.
my lord, I'll inform. Deeply appreciated.
मैं please मैं pray for listing of criminal
Can't
activity,
do it.
lordship.
Listing at what stage?
Lordship it's first
Huh?
first your lordship admission for we
Which matter you fix it? If you have filed it, you have a filing number.
yes lordship, I filed now. It was filed on 11/11/2024.
Okay, give it to the court master.
May I please, Your Lordship? I beg to mention item number 25. Maybe possible for
25.
today. Yes, Your Lordship. Maybe possible for today. Actually, my senior is unwell, Your Lordship. Maybe taken after vacation, you know.
Okay, 25, similar after vacation. Yes.
May I please, Lordship? I'm praying for listing of a IA, Lordship, for correction, Lordship, in the order, Lordship.
Let's take you to the court master.
May I please, Your Lordship? I am paid for upgrading matter item 36, Lordship. The person is in detention.
36.
Yes, Lordship.
Okay.
Deeply.
May I please, Lordship? Lordship, I welcome to item number 20, Lordship. After vacation, I am on behalf of PS Rajika. He has some personal difficulties, Lordship. Item 20.
20. Okay, after vacation.
Lordship, interim order may continue.
There's no interim order to be continued. I is either on bail or not on bail.
I am bail, on bail.
So bail, you don't have to extend it. He's on bail.
Yes.
Is it a limited bail?
No, yeah.
Then
May I please, Lordship? Lordship, I beg to mention item number 17 and 22, my lord.
Madam, both the cases, but contacting counsel is Mr. K. Locker, my lord. He is not well, my lord. Matter may adjourn.
Item number?
17 and 20. 17, 20. Okay, after vacation. Madam, obliged.
I have 40. 40 to be 4040. Upgraded item 40.
My lord, I am behind the bar since the 3 months, 11 days. And there is a delay because I have explained something that is, Lordship was not so much satisfied. So that is why he was detained. That's 15, para 19, I have explained. Actually, I am very poor lady and I had to collect donations, etc. and wanted to file writ petition. In the meanwhile, I have been arrested. On 2/9/24, page 15, para 19. So for merit of the case is concerned, my lord, I have a very good case on merit. 65 voter list, my
But Mr. M.U. Mahmood, land counsel for the applicant, also heard Union of India. But Ms. P. Barwar on it, standing counsel for respondent number 2. Mr. G. Sharma on it, standing counsel for the active matters representing respondent number 2, 4, 6, and 7. And Mr. P. Sharma on the additional senior government advocate appearing for respondent number 5. By filing this interlocutory application from the applicant, who is the petitioner in the connected WPC 5398 or 2024, is praying for release of the petitioner from the transit camp, Matia, Gwalpara, where she has been arrested and detained on when
2/9/24.
2/9/2024, pursuant to the said opinion. From the Learned Counsel for the applicant has submitted that the petitioner is in the transit camp since 3 months, 11 days. Next paragraph. The learned standing counsel for the FT matters has opposed the prayer for bail on the ground that pursuant to the opinion that as per the opinion dated 6/6/2018, the petitioner has been declared to be a foreigner of post 25 in 1971 series on her failure to establish any linkage with her projected father. And moreover, it is submitted that as the petitioner has not challenged the opinion for last 6 years, the opinion is deemed to have attained finality. Next, be there as it may. It appears that the records which is received from the examination of records which is received from the tribunal requires some time. So therefore, as the applicant has custody for about 102 days, It will be 102 days today.
Yeah.
101. 101
102
days.
days, yes.
101.
3 months, 11 days.
More than 101 days in custody. So the court is inclined to release the petitioner on bail on the following conditions. The family members shall appear before the SP border. Which place?
Borpeta.
Borpeta. And furnish a bail bond of rupees 10,000. With those conditions of 3123. As a condition for grant of bail, comma. The petitioner is, the applicant is prohibited from leaving the territorial jurisdiction of the Superintendent of Police border, Borpeta, without written intimation. So in the event the petitioner is found to have left the jurisdiction, it will be open to the state respondents to move to this court for cancellation or recall for the order of bail. This application stands disposed of. In the
My lord, one thing I am disclosing, it is Borpeta, but Bozali now has become a district. So order was passed by 10th tribunal number 10 Patshala at Borpeta. In this way, the order is written.
no, you know, I will not be able to say. You'll be able to. You are required to tell us which
It is Borpeta.
which district will give the bail. Which superintendent of police will give bail? Because if they don't have record, they will not give you bail.
Borpeta will be there. Borpeta is there.
I am not aware.
No, it is there in 10th at Borpeta, 10th Borpeta at Patshala. In this way, that is it. So Borpeta will be SP Borpeta.
That we don't know, because with change of jurisdiction, the records may be transmitted from one district to another.
Yeah.
We don't have that information. Where your records will be lying, we don't know.
But I am told the SP Borpeta has arrested her.
It's not a question of who is arrested. After the district is created, then the records will be transmitted to the Superintendent of Police Borpeta.
Yes.
Or if it is Bozali, it will go to Bozali. We don't know. I think Mr. Sigdar would be knowing more better.
Borpeta.
My lord, the police station wise, my lord, bifurcation is also there.
Police
So,
station
yes,
wise.
my lord, if the
So please
petitioner is
find out.
calling in for-
If the order is wrong, it will give you more trouble.
Yes.
Because then you'll have to apply for modification of the order. It will give you more trouble.
Yes, how do you? Yes,
Rather take.
Yes, man. Yes, how will you? It will Borpeta.
It will be Borpeta.
So, Mr. Sigdar deserves a thanks from you.
Yes, thank you, Mr. Siddhar.
Well, I am also committed similar mistake, my lord. I am also committed.
No,
No,
it
that's
is
all.
actually some confusion.
But we must compel him to thank you.
Some confusion is there in
And
that side,
in the main case,
but now it is revoked.
as the both sides are represented, as the records are received, list the matter in the admission column after ensuing vacation, winter vacation.
Obliged, highly obliged.
Upgraded item 41. Wait, please. My lord, I refer to order dated 13/11/2024.
1311, yes.
So, my lord, by that order, your lordship was pleased to call for the records and my release from custody, my lord, we considered after receiving the record. That was the order.
Okay, records. Okay. I see.
Record is not yet coming.
Records have not come.
My lord, another thing is this, my lord. After this order, my lord, I filed the IA And that was on earlier occasion, my lord, on 13/11/2024, that IA for bail was not available.
It's here. It's
My
now.
lord, it
today
is now,
on
now
board.
has come. That is why, my lord, IA will be considered after receiving the records. That will be the order.
Tuesday, make it Tuesday. This is the matter. Writing the amended petition, as the records on both sides represented, as the records are not received, the registry shall send a fresh requisition to send the to the learned tribunal. It will be the learned member, foreigners tribunal number 11th, Borpeta, for sending the scanned copy of the records expeditiously to this court for being placed before the court. Next paragraph. The requisition which shall be, a reminder shall be sent by email with liberty to the said learned tribunal to send the scanned copy of the records to the registry for being placed before the court. In the event the scanning facility is not available with the learned tribunal, the tribunal may seek the assistance of the Superintendent of Police, Borpeta, for scanning and transmitting the records to the court. Make it Wednesday. Wednesday will be 18th. We're keeping it on 18th. We'll try to get a scanned copy of the order. The records. Oh, not 17th, 19th then. 19th.
1912.
Ah, yes.
Obligation.
Yes, ma'am.
Upgraded item 42.
Maybe that's it.
Yes.
In this order, my lord, as well as in my writ petition, my lord, a case number of the FT, my lord, wrongly mentioned as a 67 instead of 65, my lord.
Now, what should be the correct one?
Correct one is 65.
65.
Should be 65.
Huh?
65, my lord. FT.
65.
Yes.
Okay. Which paragraph in the order needs
Paragraph
correction?
3, my lord.
Huh?
Paragraph 3, my lord.
Paragraph
Page 11.
3.
Other part is correct.
Okay. But Mr. A.M. Ahmed and Council of the Petitioner. Also heard Mr. G. Sharma, and standing counsel for the FT matters representing respondent number 2, 5, and 6. Mr. V. Sharma, and an additional senior government advocate for respondent number 3, and Ms. P. Barwar, and standing counsel for respondent number 4. Next paragraph. Filing this interlocutory application, the applicant who is the petitioner in the connected WPC 8243 of 2018 is projecting that there was an inadvertent error of referring the FT case number in the writ petition. Consequently, the case number is incorrectly entered in the judgment dated 11/11/2024 passed by this court in WPC 8243 of 2018. In the writ petition, which page is the opinion?
Opinion is P.S. Miller. It T2 Miller. Take it. Top. FT within bracket null 2, case number 65,
Next.
2007.
On a perusal of the photocopy of the opinion is available in an Q to the connected writ petition. It is seen that the case in which opinion dated 24/9/2018 was passed by the learned member from Foreigners Tribunal number 2, Nalbari, is FT within bracket NAL -2 case number 65/17 arising out of FT case number 303/10 memo number TNB/B/5 within bracket B/2010/1122 dated 22/9/10. 22/9/10, page 82. Black. Next one. Accordingly, prayer made is interlocutory application stands allowed. The learned counsel for the applicant shall first make necessary correction in the cost title of WPC 8243 of 2018 under his signature. Cost title as well as in which paragraph?
Paragraph 3.
No, in the writ petition, which paragraph?
Cost title may not,
Cost title.
yes. Page 1.
Cost title and prayer made in the and the prayer of the said writ petition. By referring the proceedings as FT within bracket null -2 bracket close case number 65 of it will be 65.
65.
Oh, so prayer is right. On the cost title it is wrong.
Yes,
It
yes,
not
prayer is right.
Not prayer. On the cost title. Upon such correction being made under the signature of the learned counsel for the petition applicant. The registry shall release a certified copy of this order. Next one. On condition that the corrections are made in the cost title of the petition, comma. The court is inclined to provide that the case number referred to in paragraph 3 of the order dated 11/11/2024 passed in WBC 8243 of 2018 shall be read as FT within bracket null bracket -2 case number 65 of 2017. This interlocutory application, this order shall be read together with order dated so and so passed in WBC so and so. application stands disposed of. So first you will have to do the correction only, then your certified copy will be made available.
Yes. My lord,
The correction shall be made in the presence of AOJ, FT section.
sometime maybe extend me.
Okay.
Otherwise.
Consequently, the time for appearance before the Superintendent of Police, Border Nalbari, is extended till 30/12/2024 during officers. And on such appearance, the Superintendent of Police, Border Nalbari, shall do the needful in terms of the order dated 11/11/2024. Full stop. Next, consequently, the time to appear before the for the petition to appear before the learned member, Foreigners Tribunal, number 2, Nalbari, is extended till 8/1/2024, 25. Then we can say it will get together. Okay.
Upgraded item 43.
May I please, because I have filed an IA for suspension of opinion dated 25/2024, my lord. The main case, only LCR was called for, my lord. No. Huh? No. In this case, my lord, my brother, elder and younger brothers also produce evidence, my lord, and also Gaure examined in this case, my lord.
These witnesses are set up witnesses, they don't inspire any confidence. Where is your Gambura certificate?
My lord,
Your brother does not prove anything.
in the writ petition, my lord, I have
Which page is your the Gambura?
Gaure certificate page 86, my lord.
86.
Yes, my lord, in the writ petition, my lord.
Doesn't help you, this is not a good document.
But Gaure also.
There is no merit at all.
My lord,
You look at your brother's deposition,
yes, my lord.
there's nothing there.
My lord, page 47, my lord, elder brother. My lord,
You look at his deposition, we have seen it, that's why we are commenting. He does not prove anything, he does not even prove his own residence. He does not, he came to for voting for the first time in 1989. It does not disclose he is not, his presence is not disclosed in your written statement. if he's. Where is the evidence of your brother?
My lord, page
No, sorry,
47,
your own evidence, where is that?
page 47, my lord.
47. 70 years. Mr. Sharma, 70 years of age, yeah. Then. Page 47 discloses 70 years of age.
Okay. Lordship, he is not the proceeding lordship. He is about 61 years, lordship.
Huh?
He is not the proceeding lordship. Page 47.
61 years.
Yes. He is
He just now
61
said
years.
it is 47 is his own evidence.
47 is one of my brother evidence, my lord.
No, I'm asking about your evidence. Where is that?
My evidence is page number 35, my lord.
This your brother at page 47.
Yes.
He gave his first vote when? 1989.
89, my lord.
Then what is he's also a foreigner then? How will that evidence help you?
My lord, my
Get bail.
my brother's name along with my father's name, name in the voter list of 89. Page number 78, my lord.
78.
Yes. Our department, page 79.
Where is the first voter list of your father?
Father, my lord, voter in the year, my lord, 1965, my lord.
Where is that?
Page 74, my lord. I.H. Khan. H. Khan.
H. Khan. Donor counsel for the applicant. Also had Ms. P. Barwa, done it, standing counsel for the respondent number 2, Mr. P. Sharma, done it.
10, your lordship. 2
Huh?
and 10. Also 10.
Also 10, okay. 2 and 10. And Mr. P. Sharma, an additional senior government advocate for respondent number 3 and 8. And Mr. G. Sharma, an standing counsel for FT matters for respondent numbers 4, 6, 7, and 9. Next, brother. The applicant, who is the petitioner in the connected WPC 4869 of 2024, has filed this interlocutory application for bail. Printing arrest in connection with opinion dated 25/2023. IA page 11.
2024, my lord.
24.
I think.
Then you are writing 23 somewhere.
Uh,
Look, then you have to make corrections.
I
Why you make corrections? You don't read your brief after you
sorry, my lord. I will
do the corrections. We'll take it up at 2 o'clock.
post title.
What can I do? If you have that bad habit,
Sorry, ma'am.
I can't save you. And rather we think, why should we waste our time at 2 o'clock when you don't have time to spend? We'll take it up next year. Let it be listed on Monday to make necessary correction. Why should we show our anxiety if you are so casual? There the typographical error which is kept in the connected read petition and the interlocutory application will be corrected before the AOJ FT section. Thereafter, the matter will be listed in motion column.
Yes. 44.
Yes, Mr. Siddharth.
My lord, we are also in the similar problem, my lord. Case was tried at Borpeta, Tribunal number 9. And accordingly, my lord, the lordship has allowed us to appear before Borpeta SP. We made Borpeta SP as a party. But the Borpeta SP said that his KC record is to send to Musalpur, Baksha Musalpur.
Okay.
So Baksha Musalpur SP is required to be party in the case.
Third, Mr. A.R. Sikdar, learned counsel for the applicant. Also heard Mr. G. Sharma, learned standing counsel for the FT matters for for respondent numbers 2, 4, and 6. And Mr. P. Sharma, and an additional senior government advocate for respondent number 3, and Ms. P. Barwal, and standing counsel for respondent number 5. Next, the
3798, my lord.
learning counsel for the
3798, my lord, for implement. IA.
Oh, acha. The learned counsel for the applicant has submitted that the applicant is a resident of
Village Narayanguri falling under Borpeta Road Police Station. My lord, that locality is, my lord, under Baksha.
okay, is a resident of Narayan Guri, PS Borpeta Road, which was
Earlier it was
earlier
dis-
in the district of Borpeta, but now it is bifurcated and is a part of district
Baksha.
Baksha. So accordingly, it is submitted that pursuant to order dated 6/11/2024, passed in WPC 5648 or 2024, when the applicant appeared before the Superintendent of Police within bracket border, Borpeta, applicant was the bail of the applicant was not accepted, as the records are now lying with the Office of Superintendent of Police within bracket border, Baksar,
At Musalpur.
at Mushalpur. So accordingly, by filing IA Civil 3798 of 2024, the applicant is praying for impleading the Superintendent of Police within bracket border, Baksa, as respondent number 7. And the full stop, the applicant has also filed IA Civil 3799 of 2024, Praying for modification of the order dated 6/11/2024 passed in WBC 5648 of 2024. Upon hearing the learned standing counsel for the active matters, both the application stands allowed. Next paragraph. The petitioner shall file. The learned counsel for the petitioner shall file a amended cost title in the connected WPC 5648 or 2024 to the EOJ FT matters for incorporating the same in the cost title of connected WPC 5648 of 2024. Next paragraph. Subject to the amended cost title with file. You can do it in course of the day.
My lord,
it-
my lord, I want to file on Monday, my lord. I have to post title is
subject to-
on Monday, my lord.
Okay, subject to filing of the amended cost title on 16/12/2024. The time allowed for the applicant to appear before the Superintendent of Police within bracket border. As per order dated 6/11/2024 stands modified, requiring appearance of the petitioner before the Superintendent of Police within bracket border, Baksa.
Box at me solve.
To stop the time for appearance before this Superintendent of Police border, Baksa, is extended
45/496.
for 10 days, by 10 days from today, during office hours, and to furnish bail bond of rupees 5,000 in terms of order dated 6/11/2024. Next, if the when the applicant appears, applicant namely Mohammed Shahir Ali appears before the Superintendent of Police border, Baksa, within the extended time, the said authority shall comply with the directions contained in the order dated 6/11/2024. And moreover, the authority referred to as Superintendent of Police within bracket border, bracket close Borpeta, in paragraph 6, 7, and 9 of the order dated 6/11/2024 shall be read as Superintendent of Police border, Baksa. Next, this order shall be read together with order dated 6/11/2024 passed in WBC 5648 of 2024. Both this next paragraph, both these applications stands allowed, disposed of. Okay. Corrections are only in 3 paragraphs.
My lord,
3 paragraphs of the order.
my lord. My lord, in next item, similar problem, my lord. My lord, in that case was tried at Bozali, but the
You
record
just
is,
write in a slip of paper and give it. I'll just check it and give the same dictation.
my lord,
Write in a slip of paper and give it,
my lord,
indicating the paragraphs of the order and the new authority, old authority and the new authority.
my lord,
Just write in a piece of paper and give it.
my lord.
Particular same order. And
On
also-
Borpeta, my lord, it will be,
just write it, because I am not opening the file.
my lord, my lord.
And also indicate the IA numbers
My-
for corrections of the cost title and implementing, and second is for correction of the order. Both indicate that and give it to
My-
the court master.
Deep love.
Item 1 for motion.
I have penalty order dated 30/9/2023, my lord. Passed by the foreigners tribunal number 4/3, my lord, by which the petitioner has been declared to be a foreigner, my lord, of post 1971.
Where is the opinion?
Opinion is at page, my lord, 75%. Yes, sir.
Where is the land document pata? Which page?
The document that has not been annexed, my lord.
Not annexed.
No. Exhibit 3, my lord. Exhibit 3 is the link document, my lord, of the petitioner along with his parents, my lord. The voter list of 1985. my lord. Parents' name appeared in the voter list of 1966 and 70, my lord. And 1985, my lord, the petitioner's name has been recorded, my lord, along with his parents, my lord. Parents to
But doesn't help. Oh, अच्छा. No.
আব্দুল্লাহ আহমেদ কোন? আব্দুল্লাহ আহমেদ। আব্দুল্লাহ মানে তার grandfather।
Evidence of Gaon Panchayat Secretary, where is that?
Please, my lord, please, my lord. It's 71, my lord.
What is his name? DW?
DW4, my lord.
DW4.
It's 71. May I read, my lord?
No, just a moment. It will be this is the- No. It will cross examination. The person who was against Secretary of Making has been finally counted for the present fund. Where is the evidence of this DW4? Which page?
Page 71, my lord.
71.
Type copy, my lord.
It was
In 1985 voter list, my lord, his own name has been recorded, my lord, along with his parents, my lord.
The tribunal's judgment is correct. Except for oral evidence, there is no connect with your projected parents. Is there any voter list of you along with your father?
Yes, my lord.
Which one?
This, my lord, page my lord 31, my lord. 31,
31.
32.
Is it a proof document?
Yes, my lord. Exhibit 3 was.
31.
Yes. Page 32, my lord. Serial number 196, my lord, Amanullah Ahmed is the father, my lord, father of the petitioner, my lord. And 199, Asanullah Ahmed, the petitioner, my lord.
This is you.
Yes, ma'am.
Okay. Mr. Sharma, then we are giving bail. There's one document to connect him.
Otherwise, Lordship, villages are frequently changing, Lordship.
Huh?
Since 1966, Lordship,
No shifting.
1966 and 71 is okay, Lordship, but after that, village is frequently changing, Lordship.
There's a gap, then there's no connect. The panchayat certificate is disproved.
Yes, Lordship.
No shifting is there.
Hmm?
No shifting is there, my lord.
But these
Right from
Panchayat secretary,
1966, my lord, they are residing in the same village. my lord.
panchayat certificate does not inspire confidence.
Yes, my lord.
But Mr. S. Islam and counsel for the petitioner. Also heard Mr. H. Kulil and counsel on behalf of Mr. A. Ali, standing counsel for respondent number 2, Mr. G. Sharma, and standing counsel for the FT matters representing respondent numbers 3 and 6, and Mr. P. Sharma, and additional senior government advocate for respondent number 5. Also, Mr. Sharma is for 4 also. 4 and 6. 3, 4 and 6. Next paragraph. Finally, there is a petition under Article 26 of the Constitution. Opinion dated page 75. Opinion dated so and so by so and so in so and so. Opinion dated. What is the date of the opinion?
39, 2023, my lord.
30.
Yes, ma'am.
309/2024. No, 23. 39/23.
Yes, ma'am.
Passed by so and so in so and so arising out of so and so. Declaring the petition to be a foreigner of post 25/371. Here is the records of the tribunal received pursuant to order dated 25/2024. So the records require further examination accordingly. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served within 2 days. Petitioner shall appear before the Superintendent of Police Border,
Dhubri, my lord.
Dhubri, within 10 days from the date of this order, and furnish a bill bond of rupees 5,000 with one security. Those conditions and default clause. Next, the learned counsel for the petitioner shall inform the tribunal of the next day if bail has been taken by the applicant, the petitioner. This after 4 weeks. The records have already come, huh? Not the court records.
Obliged.
Item 2 for motion.
Lordship, for the time being, Lordship, possible to mirror for the time being. Mr. Payam will submit from this week.
Item 3.
Lordship, kindly see the last order.
Yes,
We have corrected.
you have corrected it. Okay. Let me say it is Sarkar Land Council for the petitioner. Also heard Mr. G. Sharma and his standing counsel for the FT matters representing respondent number 2, 4, and 6. And Ms. P. Barwal and she's standing counsel for respondent number 3. And Mr. P. Sharma and his standing additional senior government advocate appearing for respondent number 5. Opinion is at page 20. Opinion dated 2/8/2024, passed by 7777. Declaring the petitioner to be a foreigner of post 25 through 1971 stream. Next, the learned counsel for the petitioner submitted that pursuant to order dated 6/12/2024, the name of the petitioner has been corrected in the cost title. Next paragraph. Issue notice is done within 4 weeks. Extra copies within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police border Dhubri within 10 days. Bail of rupees 5,000 with those conditions and default clause. List after 4 weeks. Receipt of records.
Publish.
Item 4.
May present. My lord.
We've seen you after a long time.
Yes, my lord.
Everything is okay?
No. My lord, this is for the second time the petitioner is before your office, my lord. And earlier direction was given to the tribunal to consider the case of the petitioner, whether the father's name appeared both in the 65 and 85, the
65
same
and
person
85.
or not. And the Home Department was also directed to make an inquiry. The concerned department make an inquiry after passing of that order, that is annexure 11. In the
Which page?
annexure 11, page 51. The police report, after making necessary inquiry. 51, the relevant portion is at 52, last paragraph.
No, but from your
My lord, earlier,
because from this writ petition
my lord,
or the imperial opinion does not appear that this inquiry report was proved.
not considered. That is my case.
No, it was never proved. You see, despite the order of the court, when this report of inquiry came before the tribunal, it is not an evidence before the tribunal. It can't take into consideration. Somebody must prove the contents.
But it was called from the tribunal itself, my lord.
No, tribunal has called it,
Yes.
but somebody must prove it.
That
Merely
is-
because some document is called,
Yes, my lord.
it can't become an evidence.
That is true, my lord. That is due to the fault of the officials concerned, my lord. Not on the fault of the petitioner.
No, it's
But-
petitioner's fault because you see, petitioner will have to prove the contents. You see what happens if you
But
call
the
for a record.
Report was officially called for.
No. Every you see in a civil suit, we may call for the record of Jamabandi, record of rights. Does it become an evidence just because I have called it? Sealed it, we call it from the sub registrar office. Does it become an evidence? No.
But he has not stated anything regarding that report.
We understand, but the difficulty is that you'll have to prove it.
Report is in my favor, my.
No, I understand, but if you don't prove it goes, the tribunal will not take into consideration any document which is unexhibited.
Then in that case, may I pray for further remand for getting a
Lordship, let the records come, Lordship.
Huh?
At least this.
No, because it is really unnecessary exercise to call for the record and then, because what is fact is fact. In the report, in the opinion, I did not read it very thoroughly, but prima facie reading, it doesn't appear that this document was proved.
Yes, Lordship.
my lord in that. No opinion there.
হ্যাঁ
আমার only answer.
ট্রাইব্যুনাল এর উপরে দেখো কোনে
We'll take it up at 2 o'clock. Let us, both of us examine what can be done at 2 o'clock.
Police report does not attend finality, Lordship. Mostly not enough scope before the tribunal, Lordship. Yes, Lordship. But enquiry regarding enquiry report, Lordship. Enquiry, police enquiry, it does not attend finality, Lordship. Tutar দিয়েছে, tutar দিয়েছে।
Item 5.
একটু আমার না হলো একটি মিটার
Legal.
কিন্তু একটি শো করা নাই যে আচ্ছা 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 ইয়াতে স্ট্যান্ডিং নাম একটি দেখো না
Of the records of the tribunal, is it 22
Prima
opinion?
facie, I have a good case and
So we
the
understand, but there is a
because
delay.
in the notice itself, there is no grounds while issuing the notice. I have annexed
So
the
everything
notice.
may be in
Lordship.
your favor, but still it's an opinion of 22.
Yes, Lordship, and
2
this
years.
is legal aid matter. I am appearing on behalf of. Because
As a
from-
legal aid counsel.
Yes, Lordship, although it's not reflected, but
Okay.
it's from Guwahati High Court Legal Service Committee. I'm being entrusted with this case, Lordship. Because while filing, I have mentioned as legal aid counsel.
Okay.
And
But
since
still as a thumb rule, we are following that policy only.
then I humbly pray if the matter is since reopening date.
We'll fix a date.
Yes, Lordship.
It goes in the second week, but we'll fix a date.
Otherwise, sister also declared Indian in the same tribunal. Sister, his sister, and in his sister's opinion also, his name and everything is mentioned.
What is that case number? We'll call for both the records then.
Yes,
Because we'll have to also examine
Yes, Lordship.
It's the same set of documents.
Yes, Lordship. And it's at page number 114, Lordship. Pointer's Tribunal number first, Barpeta case.
114.
Yes, 114, Lordship.
This is the opinion of
A sister,
Mr.
Amena Khatun. FP case number 27318.
Where is the opinion impugned in this petition?
Page 35, Lordship.
তোমার opinion নাকি? Opinion তো নাই।
Yes, Lordship.
Prima facie, they are different persons. You see, please come to page 115.
115, yes, Lordship.
The paragraph 6, line
Yes.
number 4.
Yes,
Father's name is Sohrab Ali
Yes, Lordship.
and mother's name is Basatan Nessa.
Yes, Lordship.
Now in page 35,
Yes,
is
Lordship.
son of Suraf Mia.
It's in the inquiry report, it's written as Suraf Mia.
Still,
In his WS and all, he had stated his father's name is actually Sorab Ali.
But when he says Sohrab Ali, it's Mia also in paragraph 6 of the other opinion, page 36. What are the documents exhibited in the other case, page 113 or 114?
114, Lordship, voters list of 1966, 1970, then 93 voters list, 97, 2010, Gambura certificate, marriage certificate, and judgment certified copy.
What judgment certified copy is that?
That instruction I don't have, Lordship.
Mm.
But in his
No, it will
WS
be,
and
it will be mentioned here somewhere in the discussion. It will be mentioned what judgment is that.
there were also res
Yes, there's an FP
judicata.
case of 228.
Yes,
Previous declared.
proceed, same procedure, res judicata, Lordship. Above discussion appears already declared not a foreigner. Accordingly, the case disposed of. Already she was declared in another case. She was declared as not a foreigner. So this case was
না।
Indian in FT case
Where is the
228.
page, where is the 1966 and 70 voter list?
Yes, 66 voters list is at page 90, Lordship.
This is village.
Guma, same village, all along
Oh.
same village, all the documents. Age discrepancies are there, Lordship.
Hmm?
Age discrepancies are there in the voters list.
No, we may omit that, but
Then 70 at page 92, Lordship.
any voters list you have with your father, projected
Yes,
father?
Lordship. Yes, Lordship. Voters list of 1989, Lordship.
Page?
Page 95, Lordship.
We still have to call it because in the other, there's no discussion on any of the exhibits. Page 117, there's no discussion. The court has gone into that exhibit
Yes,
I.
already she was declared as
Therefore,
Indian.
there's
It's
no
the
discussion.
reason
We are not
that
getting this facts clear.
Notice I have annexed lordship, notice. Lordship may call for the records, or both the records, lordship.
Right. Mrs. D. Ghosh, legal counsel for the petitioner. Also heard. Mr. G. Sharma, and standing counsel for the FT matters representing respondent number 2, 4, and 6. Ms. P. Barwar, and it's standing counsel for respondent number 3. And Mr. P. Sharma, and it's additional senior government advocate for respondent number 5. By this representation on Article 226, the petitioner has assailed the opinion dated page 35. Opinion dated 18/8/2022, passed by so-and-so in case number so-and-so, IMDT reference number so-and-so. Thereby declaring the petition to be a foreigner of post 25, 3/1971 stream. Next paragraph, the learned counsel for the petitioner has submitted that the sister of the petitioner has been declared to be an Indian citizen earlier by
Yes, basically.
opinion dated 5/11/2015, passed in FT case number 228 of 2014, and upon a fresh reference being made, the sister was again declared to be an Indian citizen pursuant to opinion dated 4/5/2021, passed by the same learned tribunal in FT case number 273 of 2018. Comma, inter alia, comma, the same set of documents. Next paragraph. Better notice it returnable on Seven 1/2024 be issued. Requisite extra copies of the petition will be served on the rendered CGC State and Department Council within two working days. That the records of FT case number 345 of 2018, as well as FT case number 273 of 2018, and FT case number 228 of 2014 be requisitioned from the Foreigners Tribunal number 1st, Barpeta. Next part of the registry should send the requisition through email to the following address of the learned tribunal. You give the Mr. Sharma the email address of this tribunal.
Yes, Lordship, I have provided already.
You provided. Okay. And this so address. Take it from him. Next part. The prayer for bail shall be considered on receipt of the tribunal records. In the meantime, if the petitioner is apprehended, he shall not be deported out of the country without order of the court. Next para, list on 7/1/2025.
Deeply.
Oh, Miss Ghosh. Oh, that the other matter is fixed on that day, 8th there.
8.
That repression criminal is pending on that.
Yes, lordship. Not
8th.
on 7.
Not on 7/8.
Yes. Declare.
Item 6.
Maybe lordship. This is the second round of litigation, my lord. The earlier the petitioner declared winner, my lord, but some document was not annexed, especially my lord, the voter list of um, um, 87 and 90. Then this honorable court directed to this tribunal to submit the document, my lord. See the honorable court's order, my lord, 9 page 69 annex 18, my lord. And this document, but only I have gone through the report only.
This is not
Discrepancy of the
connected,
age.
you could not connect yourself to your projected parents.
My lord, kindly see order, my lord. Page,
You then say
69.
that you have shifted somewhere else.
my lord, I have shifted, but my name, recorded with my father, my lord, as per this court, my lord, 69.
69.
69, and next
69.
18. Yes, my lord. Honorable court's order, my lord. High court's order.
Yes.
There are 3, my lord. Married, my lord. And direction was given, my lord. There are 5, my lord. And 6. There are 5 and 6. And in
Where is the opinion?
my lord, opinion, my lord, page 73.
73.
Yes, my lord. 72. And my lord, relevant this part, my lord, 80, my lord. Regarding this 2 document, my lord. 80, page 80, document 3 and document 4. Read that relevant part, my lord. We have submitted the 2 document voter list, my lord. 89 voter list, 97 voter list. Only the minor discrepancy of the age, my lord. As per direction, this
Which document?
my lord, voter list of 1989 and 1997, my lord. Page 80, my lord.
That is exhibit numbers?
My lord, exhibit number, my lord, document 3. Here it written as a document 3. Document 3.
Document 3 was rejected because it's a photocopy.
No, my lord, certificate code, my lord. Certificate code, my lord. Document here we mentioned as a document 3, computer generated, my lord. Kindly see my document, my lord. Not photocopy, my lord. Certificate copy, my lord.
Where is the document?
My lord, 89 voter list, my lord. Certificate copy, my lord.
89.
89. It is the document, my lord, page 27, my lord. 89.
27.
27. Page 27, my lord. 89 voter list, my lord. That was a submitted, my lord. Certificate copy. And next, my lord, 97, certificate voter list. 97 also certificate voter list. Page 29. Only minor age discrepancy. I have done.
This is exhibit number?
My lord,
Page 29.
page 29, my that document they by the document number 4, my lord. Document number 4. Document number 4. Page 80, document, it mentioned as a document. And my lord, earlier it was not, retail or not exhibit. As for direction, this court's order we submitted, my lord. These 2 documents.
No, this we'll ask the Mr. Sharma. If your home department does not take care of these things, then we'll come very sternly. We'll pass orders. We shall take away the entire credibility of the tribunals. This can't be permitted. If this exhibit, this annexure, this page 27 and 29, if it is rejected like that, we'll have to write that these officers are premeditated and they will be removed. The entire credibility goes of the tribunal. We take a break and come back. Both of you decide. Prima facie appears that these are premeditated mind of the tribunal working. If you don't train them, these officers will not take up any other tribunal cases from today. We'll prohibit them from acting as tribunals. We'll prohibit them. Today we will pass the orders. This tribunal will not function from tomorrow. We'll take a break and come back.
I'm sorry, my lord.
No, what we'll do is we'll call for the records first.
No, your lordship, kindly, because your lordship has raised certain doubts.
Hmm.
My lord, the documents 3, the tribunal has not doubted anything. But it is the, my lord, exhibit 3, which was photocopy. Documents 3, the tribunal has slightly discussed, my lord. Probably the petitioner has placed some, my lord, the documents 3, page 27, it is documents 3, exhibit, not the exhibit 3. Document 3, tribunal has rightly discussed, my lord.
My lord, kindly see my page 27.
Let me argue, my lord.
Let him complete.
Yes. Page 27 is the document 3, my lord.
No, because I've asked, he said that it's document 3, it's marked as document 3.
Yes, document 3, your lordship will find. In fact, page 75 itself.
75.
Yes, that is the opinion of the, my lord, tribunal, as well as, my lord.
Computer printout.
Yes, as well as page 80. Details discussion is there in page 80 with regard to documents 3, my lord.
Yes.
Document 3, there is no doubt, my lord. Only exhibit 3 is a different thing, my lord. Document 3 is a different one. So your lordship is.
Oh, is it because I'm asking, Mr. Ali is saying that is.
No. Exhibit 3, my lord, your lordship will find in the earlier opinion. Page 65. What is the exhibit 3, my lord?
That was not exhibit. Earlier, this document was.
No,
just a moment.
Yes,
Mr.
sorry, Lord.
Mr.
Exhibit 3 and document 3 is a different thing. That's why my
No, it's
learned
okay.
friend is committing mistake.
Where is
Page
that?
65. Page 65, man.
65.
This is the earlier opinion. Here it is exhibit 3. Exhibit 3 is a different document, my lord.
Please, epic.
Yes, man. 3 is epic. Exhibit 3 is epic. Photocopy of epic.
Now
And
here, where is the reference to exhibited documents
it is
in this opinion?
in latest opinion, my lord. Yes, it is page 75, my lord.
Exhibit 3, photocopy of a document.
Yes, ma'am. Then your lordship will find after from serial number 10, it is document starts, ma'am. Documents which they have exhibited now, my lord, after the remand by this honorable court. And this page 27 is this document number 3 of my lord, item number 12 in page 75. And this state discusses this here.
No, just a moment. Please come back again.
My lord, as your lordship has doubted page 27.
Just a moment. Let me come back to it.
Yes. Page 27, your lordship. Your lordship is probably looking this document, page 27.
Yes, 27 is document 3.
Document 3.
Yes.
This is discussed in page 75 as well as page 80, my lord.
Just a moment.
Page 75 at serial number 12. my lord.
27 is document number 3.
Yes.
Is page 75.
75, serial number 12, my lord, last paragraph. And detailed discussion is at page 80, my lord.
What I say?
And details discussion on document 3 is at page 80, my lord. 80.
80.
Yes. This document 3, 4, 5, 6, document 6, all are discussed here, my lord. There is no doubt on the document itself. And this exhibit 3, my lord,
is an epic which is
epic,
photocopy.
which is not probably annexed here. My lord, which is not probably annexed here. So exhibit 3 is the epic.
So, Mr. Ali, you are wrong.
My lord, kindly see just
Time
27.
again, second, 2 times we asked you about the exhibit. You said it is marked as document.
Document, my lord. The tribunal itself,
So,
my
but
lord,
this
document number
this
3.
document is not doubted.
My lord, page 27. Here, right, my lord, document 3. member, foreign tribunal.
Yes, so this is not a doubted document. We firstly flared up.
No, my lord, that this document was executed, my lord. And earlier,
My
my lord,
friend is probably.
Where is the additional evidence filed after the matter was remanded?
my lord, that additional document is not annexed here, my lord. But this document placed before the tribunal, my lord.
No, placing before the tribunal and proving it are two different things. Because we were under the impression that you have proved
My
it
lord,
and
my lord, kindly see the page 27, my lord, here, my lord, kindly. Document 2023.
it's okay. Document 3 itself doesn't become an evidence.
And this total list, my lord, kindly write details here, mention, my lord. Details, right? Document 3 not dated in, that was not in written statement, my lord, earlier. So clearly stated, my lord.
No, it's stated, but it's not discarded.
Not discarded.
Stating something and discarding it are different things.
Yes, my lord. But only the age discrepancy, these two documents, my lord, age discrepancy mentioned, my lord. And my lord, total list, here, my lord, age, my lord, here, 8286, serial number, my lord. Allowed age 12, 27 document, my lord, discuss here. Page 80, 27 document is discussed. my lord. My lord, 89 and 97, this document was not annexed earlier, my lord. Earlier, and that was not mentioned in the written statement also, my lord. So court directed to produce this document. Accordingly submitted, my lord.
Where is the voters list of 66 and 2005?
66, my lord. Page 22, my lord. And vernacular page 23, my lord.
Where is exhibit 7A?
7, my lord.
Something we are not being able to follow, Mr.
My lord,
Pai.
please. My lord,
Mr. Pai, please come to this page 85.
Yes.
Third paragraph. Page 85, third line. Second line, Jamila Khatun as wife of Mekai Mia in the year 1966. Correct.
Yes,
Now 66 is page 23.
exhibit 7A.
Exhibit, I don't know. Here I'm finding year 66 and therefore 66 is page 23.
yes.
The name of
66. This is not the exhibit, my lord. This is document number 1. This
no, I'm just that's why I'm showing you. Page 85 says 66. Jamila Khatun.
yes, ma'am.
So where is that document? Mr. Ali?
That is not 7A, exhibit 7A, my lord.
So where is that?
It's not an ex. Probably that document is not exhibited next now.
Earlier, you also not exhibited. All the document was exhibited. Two voter lists on My lord, written statement, my lord. Yes, 52, my lord. 52, 52. Written statement, my lord, they are not clearly mentioned. So earlier it was rejected.
Have you disclosed how many
No, my lord, there nothing.
how many wives your father had?
My
No.
lord, in the retrenchment, nothing mentioned, my lord, earlier occasion, my lord. So that retrenchment, subsequently no retrenchment was held, my lord. Simple
Then
retrenchment.
you have no case at all.
There is case, my lord, but the retrenchment, it was done, my lord, earlier
So
occasion.
not only that, the pursuant to the tribunal's order, this court's order, you did not prove the document. You just filed the document. That's not enough. Without an evidence, the tribunal cannot consider any of your documents.
And direction on the
And when we are asking you, say that this is the only a document marked as document, it is not an evidence at all.
my lord, here
Yeah.
the mention your document number 3,
I-
page 27, tribunal write down, my lord. I have
I
seen.
wrongly expressed my anger.
Well-
It was a mistake on my part.
My lord, petition in the manner in certificate copy, document number 3,
No, it cannot be considered. If it's a document is not proved, this cannot be considered at all. There's no infirmity in the opinions.
this is the certificate copy, my lord. 89 and
We have
97.
seen, we know how to deal with certified copies. Consider a prayer for bail on receipt of records.
97 and 89, my lord, both the
No, if you
document.
don't prove it, we can't help you. Consider a prayer for bail on receipt of records. But Mr. H. Ali, learned counsel for the petition, also heard. P. Barwar and its standing counsel for respondent number 2, Mr. J. Pang, and its standing counsel for FT matters representing respondent number
3, 5, and 6.
5, and 6, and Mr. P. Sharma and an additional senior government advocate for respondent number 4. This is the second round of writ petition by the petitioner. So by filing this writ petition, and you take the format from them, huh? The page 73 is the opinion dated
12/3/2024. It's 77 on the page.
date is not given.
Yes, given my lord. Page 77. It's not font side, middle side is what date given, my lord. Order it is in.
Page 77.
Yes, my lord. Opinion come final order.
Okay. Opinion dated 12/3/2024. Passed by so and so, page 73. In FTD case number, that will be first corresponding to FT case number so and so, arising out of SPB FT case number so and so. It will come in serial order 1, 2, 3. By which the petitioner is declared to be a foreigner of post 23rd 1971. Next paragraph. At the outset, the learned standing out for the FT matters has opposed the admission of this writ petition on the ground that the documents which were produced by the petitioner pursuant to order dated 15/2/2023 passed by this court in WPC 487 of 2018 were not proved in accordance with law. Next paragraph. Be that as it may, issue notice returnable on eight 1/2025. Extra copies of the petition be served on the learned CGC, State and Department Council within 2 working days. Let the records of the tribunal be requisitioned from the concerned tribunal. First of the requisition shall be made by email at the following email address of the tribunal. Next, the prayer for bail shall be considered on receipt of the records of the tribunal. Next, in the meanwhile, it is provided that if the petitioner is apprehended, he shall not be deported without the order of the court. Next, list on 8/5/2024. Oh, sorry, 8/1. 8/1. 8/1.
My lord, accept it another day. Accept it another day, my lord.
No, because we are then at the last date.
Any day, my lord. 8, but accept it.
Okay, make it 6/1. 6/1. Okay.
Hello, Brash.
Item 7.
May please, your lordship.
Yes, Mr. Hussain.
My lord, including the opinion at page 58.
2014.
21.
Huh?
Annex 14.
21. Okay. 21. Okay, we'll consider a bill on receipt of tribunal records.
My lord, there is some debate. She is a lonely lady, lordship.
Huh?
She is a lonely lady, lordship.
Still, there is an opinion. We can't help it. We can't encourage such default.
Lordship,
Actually, default is under compulsion lordship. That is not, she is a lonely lady lordship. After death of her husband, she started to live with her brother lordship, along with her daughter. Daughter also died lordship. Now she is lonely lady and poor lady lordship. Therefore, I have explained the delay lordship is paragraph 16 lordship. That part may.
I don't know if she's old, then we would be oldest. Oldest. And then what you will. What do you think of ourselves? Brother and sister sitting here.
It's very energetic lordship.
There are many of your friends behind will be antagonized when I tell them their age, the age of the petitioner. Are you secured? Many people may catch you outside. So therefore, I'm asking you: do you have security personnel for you? The petitioner is 51 years of age.
Yes.
You called her old.
Lonely lady lordship. And
No, that's okay.
delay that occurred not intentional lordship.
51 is old, and we are oldest, and then there will be many people catching you behind. 51 to be old.
Age also depends on living standard lordship. That is, these are rustic.
No, but
village-
since it's as thumb rule, we are not giving you bail. If you're
Otherwise-
taking the litigation so casually,
Otherwise, lordship, she has a good case lordship. And the
no, we don't
delay-
say you don't have a good case.
Yes,
It's only because of the default, we don't want to give you bail.
lonely lady lordship, not intentional delay lordship. Lordship, I have explained at paragraph 16.
Paragraph
16 lordship,
16.
page 15, paragraph 16.
প্রমাণ করুন তো।
He is living with her elder brother. Page 36 is the voter list of 2018. Her elder brother's name along with the petitioner and her daughter appears. But thereafter her daughter also died lordship. One more.
Where is your voters list?
voter list,
First entry in your voters list, where is that?
From 2016 lordship, 34.
34.
34 lordship,
Of which year? 2016.
2016 lordship.
But then you have many unexplained lack of entry in the voters list. If you are 51 now, you will be born sometime in 1973. 21 is 1994. Your name would appear in the voters list.
In the evidence by DW2, who is the elder brother of the petitioner, he stated that the petitioner casted his vote along with the petitioner in the year 1997.
1990?
1997 in his evidence also.
97. Is there a voter list of 97 available?
That is available, but only brother's name is there, lordship. Certificate in the certificate copy, only brother's name is there.
That's not a proof.
Lordship.
Oral evidence will not.
And lordship, in the impinged opinion, lordship, there is no at all discussion about DW2, DW1, DW2, no discussion at all. Lordship may kindly see. Documents which are exhibited, these documents are not properly exhibited. Only
Where is
the
your written statement? Have you
written
introduced your
statement is
brother there?
42 lordship, a written statement.
Have you introduced your brother there?
Yes, lordship.
Where is that?
Page 42 lordship. Para 11 lordship may kindly see. Actually, the brother who adduced at TW2, his name appears from 1951 NRC, then 1966, 70, all along with her parents' lordship. From 1951 till date, he is their lordship, and he adduced witness as DW2.
Your brother's evidence doesn't inspire confidence.
Page 53 may kindly see lordship.
We have seen it. You see, your brother's name changes. Then he does not remember your birth. After that, his address, voter list changes from time to time. 66, 70 is in the same village. Then he's in another village. 89 he's in another
Only
village.
one shifting is their lordship.
No, two shifting.
Lordship.
At least two shifting, we can find it from page 53 and 54. Yes. And then your name changes.
Spelling mistake is their lordship.
A cannot be B. I can understand spelling of A is different. But A can't become B.
Somewhere Bodhiot and Bodhiar. These are some
No. Your doesn't impress us. You see, first name is Bodhiot Jamal
Yes, sir.
Sheikh.
Yes, sir.
Then it becomes in exhibit 1 and 2. What happens?
Yes. Exhibit 1. Exhibit 1 also Bodhiot Jamal Sheikh, page 25 lordship.
Father's name is changing lordship.
Mohez.
Mufis.
Mohez.
Mofizuddin.
Mohezuddin Bodhiat Jamal Sheikh
Yes.
in 27.
25, 27, same name lordship. Bodhiot Jamal Sheikh. And same appears in the evidence also lordship.
No, let us see, let us get the records. Mr. M.I. Hussain, and counsel for the petitioner.
Lordship, there is our High Court judgment, Lordship, on the ground of non-discussion of the evidences, Lordship, the opinion cannot sustain, Lordship. In that time, Lordship, I am seeking for protection till the records come, Lordship. That may kindly be considered.
No, it's a difficulty. You don't, if had you come in within time, you will not, you don't even ask questions.
Yes, Lordship, difficulty I have
But
explained.
this, there's a lot of delay
I have explained, Lordship.
because you see, exhibit 4, 5, 6 are post 71 documents. If you don't relate it to the persons, then this,
That is related, Lordship. Lordship, there is link, Lordship. Maybe post 75, 71. Link is there, Lordship.
how?
The entries may kindly be seen, Lordship.
Hmm?
Entries may kindly be seen, Lordship. Entries.
Yes.
Lordship may kindly see page 24, exhibit 1. Shabazuddin Sheikh, page 25.
Page 24.
25, relevant portion, page 25. Shabazuddin Sheikh is my paternal uncle, Lordship. Serial number 92. And serial number 94 is Budiya Jamal, who is my elder brother, and he deposed as DW2. And Lordship may kindly the same at page 27. This is 1970 voter list. Serial number 98 is paternal uncle, and 100 is elder brother. Then Lordship may kindly see page 30, relevant portion at page 31, exhibit 3. Bodiot Jamal. This spelling mistake is there, but Bodiot Jamal is there. Bodiot Jamal is my elder brother who appears in 1966 and 1970. And Bodo Bewa is my mother. Bodo Bewa's name appear, Lordship may kindly see, that was not exhibited, but I have annexed here, Lordship, page 23.
Just a moment. You see, please try to overcome this paragraph 3 at page 59. Because these things are not treated. That your brother was living in the paternal uncle's paternal grandfather's house. Those things are not there. Thrice your village changes. We don't have a connect.
Similar names are there.
No, names are so common. All these names are so common. There's no explanation given. The relevant dates are not there.
Shifting is
Because your own name does not appear with the with any of your family members at any point of time. Is there any voters list of you with your parents?
parents, no lordship.
No.
But elder brother, my name is there along with elder brother. Elder brother's name is there with my parents lordship.
Where is that?
Lordship may kindly see page 25, Bodiot Jamal, and page 27, Bodiot Jamal.
Yes.
He is my elder brother lordship. Those are exhibit 1 and 2. The list of 1966
Yes, but
and
you
7.
two are not together.
But my name is there in 2018 total list along with Bodiot Jamal.
But where is that gap? How do you fill up that gap?
There is a land document also that was not exhibited, but I have annexed here lordship may kindly see that also.
Which page?
Page 38.
38.
Yes, lordship. My elder brother's name is there, serial number 4. Father's name is there, Mojuddin Sheikh. Then
Serial number 4.
serial number 4, page 38. Above serial number 1, father's name is there, lordship, Mojuddin Sheikh. Then Soyad Jamal, he is another brother. Sabat Sheikh, paternal uncle, lordship, as lordship has seen in the documents of 1960.
No, you see, this entry is not of prior to 1971.
Yes,
It is sometime after 85.
This is not exhibited lordship.
No,
Not
but
present
still,
record.
okay. One Mr. Hussain is saying we are looking into it. Yours is the original.
All these persons are there, lordship. At least we can presume that they are connected, and names are theirs, lordship.
Yes, given the order? No. I have given the order. Okay, only that. Okay, by this writ petition. The opinion is at page
58.
58. This is 2/3/21.
Yes, Lordship.
2/3/2021 passed by learned member Foreigners Tribunal. So and so in case number so and so, PE number so and so, declaring the petitioner to be a foreigner of post 25/3/1971 stream. You should notice returnable on 8. Eight or 7? 8. Okay, 8/1/2025. Call for the records. Most of the prayer for bail shall be considered on receipt of the tribunal records. Next, in the time meanwhile, if the petitioner is arrested, she shall not be deported out of the country. Mr. Say, call for the records. From the learned tribunal, first of the requisition shall be sent by email to the following email address. It's based on so and so. There is 8/1/2025. Continue to. We'll go by, we'll call for the records, examine it and then pass on
Yes,
those.
yes, Lord.
But Dr. P.K. Goswami, learned counsel for the petitioner. Also, Mr. G. Sharma, learned study counsel for the FT matters, representing respondent number 2, 4, 2 and 4. And Ms. P. Barwa, learned standing counsel for respondent number 3. And Mr. H.K. Hazarika, learned government advocate for respondent number 5. Next, for that. Which page, Dr. Goswami, is that opinion?
Page 52. Inquiry report. It starts from 51.
No, opinion.
No,
Page
opinion.
54, Lordship.
54.
Yes.
Page 54. Opinion date 28.
No, this is not.
That is the earlier order.
Earlier order, Lord.
No, not this.
Yes, Lordship is.
Continue on, my lord.
No. I think some mistake has happened.
53, it starts from 53, my lord. 21 December 23.
No, I think then there is a mistake.
Lordship.
There is a missing page.
Yes, Lordship.
You see, 53 should continue at 56, but it is incomplete. One page is missing. 53 and 54 are different.
Yes, Lordship.
It should be 54, 55 first, then annexure, then page 53 should come. But one page is missing. Because page 53 is not in continuation to page 56.
Yes.
53. Last line, my lord.
You see, page 53 and page 57 are connected. Because page 53 says opinion dated 21 December 2023. Page 54 and 55 is 2017. Again, at page 57, you will find 21 December 2023. So 53 and 57 are connected. Therefore, 56 is also connected, but a page is missing. Because page 53 is not in continuation to page 56. Something is missing there. Please check up, Dr. Goswami. Have it listed next week.
Yeah.
You just said both sides are represented.
22nd.
The learned counsel for the petitioner shall examine if the if annexure 12 is set out in correct order. Full stop. Next point. On when?
22nd, my lord.
22nd বন্ধ।
You have a calendar in your front. There's a calendar pasted in your front.
My lord.
No, calendar is there.
What?
আগত ল'ব লাগিব date।
কিমান তাৰিখ?
13।
18th.
18th. This one, 18, 12, 2024.
Oh, Lordship, I think it is correct. I think it is correct, Lordship. The petitioner opposite party, Shamsher Ali, son of Hasmat Ali, resident of village Tugunbahi under Moidabari police station of Morigao district, was once declared to be a foreigner of post 25/3/1971 by an order opinion passed by the FT5 Morigao on 28/2/2017, which is as follows.
Okay.
Then that
Earlier,
after
quoted, my lord.
after that, Lordship, page 56, Lordship, thereafter. Earlier order is quoted, Lordship. I think, Lordship.
Okay. You see, we are changing the opinion date page. Then it will be page 53, opinion dated 21/12/2023, passed by so and so in so and so. Declaring the petitioner to be a foreigner of post 25/3/1971 series. Okay, you should notice returnable in 4 weeks. Requisite extra copies within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police border, Morigao, within 10 days, bail of rupees 5,000 with conditions and default clause. 10 days to take bail. This after 4 weeks.
Most obliged.
Time being item 2.
My pleasure. This is. Station.
Yes.
Petitioner is asking for a registration after
4 years.
4 years. of-
Yes.
The issue there was, my lord, whether that can be allowed as now or not. The law says, my lord, 2009 rules. Citizenship rules 2009. My lord. Rule 19 deals with the registration. My lord.
Citizenship rules.
Yes, ma'am. Citizenship rules 2009. This is this book at page 29, ma'am, in this. Page 20.
Yes.
Rule 19, my lord. Registering authority for the purpose of subsection 3 of the section 6A and form of registration. The central government may for the purpose of yes. Subsection 3 of 6A, under subsection 3 of 6A is the 6671 stream. Appoint an officer not below the rank of additional district magistrate as the registering authority for every district of the state of Assam. An application for registration under subsection 3 of section 6A shall be made in the form so and so by the person to registering authority for the district in which such person is ordinarily a resident within a period of 30 days from the date of receipt of order of the foreigner's tribunal declaring such person as foreigner. It is normal law. Then provided that registering authority may, for reasons to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 60 days. Then 2A, madam. A person who has been declared as foreigner, this is a special case, my lord, who were declared prior to 2013, my lord. Foreigner by the foreigners tribunal prior to 16 July 2013 and has not been registered under subsection 3 of section 6A for the reason for non-receipt of order of the foreigners tribunal or refusal by registering authority to register such person as a foreigner on account of delay within a period of 30 days from the date of receipt of the order passed by the foreigner tribunal or from the date of publication of this notification, make an application for registration in form number so and so to the registering authority of the district in which such person is ordinarily resident, provided that the registering authority may, for the reason to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 180 days. This is a special circumstance. Those whose persons were declared prior to 2013, but they did not, somehow they did not receive copies.
No, these issues were already
Yes.
well decided earlier in earlier
Yes,
cases.
numbers.
Till
So
now,
this
we
is
were
the normal law, my
doing
lord.
it. We were
Yes.
doing it.
Yes.
The High Court was extending the time for
Yes.
registration.
Now, my lord,
Now,
after the
post-
judgment of Honorable Apex Court,
yes,
what
that's
will be the situation? My lord, for that, my lord, this is reported, in fact, 2024, volume number 5 in GLT also. In judgment, in that, my lord, the majority view of the judgment, in the majority decision, my lord, there are some observation, the same at para 237, my lord, in the judgment of the Apex Court, in this 6A Citizenship Act 1955 judgment. Probably the same parameter in SCC also, because paragraph is not changed probably. Paragraph 237.
Starting from further.
SCC details.
yes,
Para 237, my lord, this is just an observation, not in fact. Further, the migrants who came to Assam on or after 1/1/1966 and before 25/3/1971, will have to be subjected to the following conditions and process in addition to the conditions stipulated above. There are some conditions under 6.3A, 6.3. The conditions that he should be ordinary resident of India who come in between 66 to 71, that has to be determined by the tribunal. Under those are the conditions in 6.3. Now these conditions, sir, they are put by the Apex Court on the basis of this rule. Such persons should have been detected to be foreigner. Section 6A1E makes it clear that person is deemed to have been a foreigner on the date of which tribunal constituted under the Foreigners Tribunals Order 1964 submits his opinion to the effect that he is a foreigner to the officer or authority concerned. Number 2, such persons thereafter should register themselves in accordance with the provisions of Citizenship Rule 2009 with a registering authority as specified therein. Rule 19 of the Citizenship Rules 2009 deals with the registering authority who would be an officer not below the rank of additional district magistrate. Number 3, thereafter, as per Rule 19.2, an application for registering under Rule so-and-so would have to be made by the persons so detected by tribunals before the registering authority within 30 days of such detection. Such application must be made within 30 days of the appointment of the registering authority. This is important, my lord. Then the registering authority would thereafter enter the particulars of application in form number so-and-so and return a copy of the application under his seal to the applicant. Then number 5, my lord, the authority would send such a copy of the application to the central and state government, which quarterly return from in form number so-and-so. Then 6, my lord, further, as per section 6A4, a person registering under the process mentioned above would be entitled from the date of detection of the foreigners until the expiry of 10 years from the date, the same right and obligation as an Indian citizen, except the right of vote. And Rule 20 of the Citizenship Rules 2009 also allows the registering authority to make a fresh reference to the tribunals upon receipt of an application from an applicant when any question arises whether such person fulfills the necessary criteria or the tribunal has not recorded as finding of the effect. So this is the observation with regard to 6A in the majority view. Now in the next part, the directions.
Number
2. In conclusion direction, my lord, of the majority view at page 163, para 391. There, in fact, my lord, though it is directed, but exactly that direction is not there, that he should register within 30 days. That direction is not there. How of the judgment, my lord. Then, my lord, there is observation by in the next minute, last, my lord, 218 of the minority view in 281, my lord. 281D. Or 218, my lord. But what my submission will 391, we hold that. Yes, we hold that while the statutory scheme of 6A is constitutionally valid, there is inadequate enforcement of the same, leading to the possibility of the widespread injustice. Further, the intention of 6A, that is to the restrict illegal immigrants post 1971, has also not been given proper effect. Accordingly, we deem it fit to issue the following directions. Directions are, my lord, in view of the conclusions drawn in paragraph so-and-so, it is held that section 6A of the Citizenship Act 1955 falls within the bounds of the Constitution and its valid piece of legislation. B is important, my lord. As necessary corollary thereto, immigrants who entered in the state of Assam prior to 66 are deemed to be citizens Number two, immigrants who entered between cutoff date of 1966 and 25/3/1971 can seek citizenship subject to the eligibility condition of prescribed section 6A3. That is my lord determination that he is coming within this period. Then number three, immigrants who entered the state of Assam on or after 25/3/1970 are not entitled to be protection conferred by section 6A, and consequently they are declared to be illegal immigrants. Accordingly, section 6A has become redundant. Those immigrants who have entered the state of Assam on or after 25/3/1971. This is my lord, the direction, my lord, and there are some other directions. Now, my lord, what my submission is, my lord, if we lordship may kindly sit in minority view in para 218. In the last, my lord, part of the judgment. This is the observation, summarize conclusions by the minority decision view. There, along with others, my lord, one conclusion is that at my lord 218, directly I'm coming to D, my lord, which relate to particularly of this my lord issue. 218 D, my lord. My lord, D. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and who have been detected as foreigner but have not registered themselves with the registering authority within prescribed time limit as per Citizenship Rule 2009 will no longer be eligible for the benefit of citizenship. So this is the view. This is not my lord substitute of the my lord earlier my lord directions or my lord the conclusions made by the majority. This in fact substance, my lord, not substitute, but it substance the my lord it adds the my lord some directions along with the earlier my lord the directions. It is my lord in earlier direction, in the majority direction, this point is not there, but it is not denied by the my lord earlier my lord the larger bench, larger my lord view. The larger view, yes, majority view has not denied it. This is a substance of the my lord. So my submission is that my lord, this point is it is the first in the entire judgment. This is the point, my lord, where this point is discussed, and this point is my lord concluded. So this can be accepted by this noble court because your lordship may kindly see what's the language in 683, my lord. 683 language may also be seen because it is not that, my lord, 6A language of 683, my lord. So in page 7 on this book, in this book, my lord. At page 7. (6A2) it is clearly said, my lord, deemed to be citizen of India, my lord. Your lordship may kindly see 6A2 first. the language, subject to the provision of subsection 6 and 7, all persons of Indian origin who came before 1st January 1966 to Assam from the special territory, including such those whose names were included in the electoral roll used for the purpose of general election to the House of People of 1967 and who have been ordinary resident in Assam since the date of their entry into Assam shall be deemed to be citizen of India. In here, it is clearly said, shall be deemed to be citizen of India as from the first day of January 1966. Now, kindly see the language of 3, 6.3. Subject to the provision of subsection 6 and 7, every person of Indian origin who came to Assam on or after first day of January 1966, but before 25th day of March 1971 from a specified territory, and had since the date of his entry into Assam been ordinary resident in Assam and has been detected to be a foreigner. So they are detected to be foreigner. So they are detected to be foreigner and they have been given chance to register within 30 days to get a benefit of 6.3 months. It is not that they will be deemed to be foreign. Then only on registration they will get So this right will come only after registration, whatever right they have. Otherwise, they are foreigner. As on otherwise they are foreigner. So my submission is that this, as this honorable apex court has in this judgment, has again reiterated the same point that they should register within 30 days limited period prescribed by the rules 2009. It should be accepted,
Yes, my respectful and deeply obliged, my lord, for the questions hearing, my lord. My respectful submission, I'll conclude it in 2 minutes, my lord. It was in direction, my lord, since it's a minority, my lord. It's got persuasive value, my lord, but it's open door for evaluation for law, my lord. And that evaluation has to start not from me, my lord. My respectful prayer will be. And then, my lord, on law point, my lord, I have got 2 judgment, my lord, on a similar point which my learned friend has apprised this court, my lord. This AIR 1968 Gujarat 124, my lord. While dealing with a situation such as this, my lord, I am repeating the citation, my lord, 168 AIR Gujarat 124. Paragraph 14, my lord, is very difficult. AIR 1968 124, my lord. This is in paragraph 14, my lord. I'd like to read the paragraph 14. Before we conclude the above topics, we may mention that Mr. Narabati had urged that the minority decision recorded by the Shankar judge in Gordadan Das case, AIR 1963 SC 1742, was not a binding authority, full stop. He based his contention upon Article 141 and 145, clauses 4 and 5 of Rule 3 of the Order 13 of Supreme Court rules. We are not called upon to decide the interesting question because the learned questions for respondent did not raise any such contention for the decisions. They concede that the judgment of Shankar judge was not a binding precedent, but they contended that the judgment of judge of the highest court in the country is of great persuasive value. Mr. Narabati does not raise any objection to the line of reasoning, my lord. This is the only authority that I have, my lord, that can at least give some kind of idea, my lord, about how situation like this has been handled. And the second judgment that I'm relying, my lord, is the Supreme Court 2023 Liblo SC 660 223 INC 736, my lord. This is in paragraph 13, my lord. Almost similar line of observation, my lord. Second judgment, my lord, 2023 live law SC 660. My lord, in that case, civil appeal number 51. Okay, I'll hand over the printout, my lord. May I read the ratio, my lord? Paragraph 13, my lord. It is settled position of law that only the ratio decidency of a judgment is binding as a precedent. In B. Sharma Rao versus Union Territory of Puducherry, AIR 1967 SC 1480, it has been observed that decision is binding not because of its conclusion, but with regard to its ratio and the principle laid down therein. In this context, reference could also be made in Quinn versus Lytham 1901 SC 495 within bracket HL, wherein it observed that every judgment must be read as applicable to the particular facts proved or assumed to be proved, since generality and the expressions which may have been found there are not intended to be expositions of the whole law, but governed and qualified by the particular facts of the case in which such expression was found. In other words, a case only an authority for what it actually decides. In this case, my lord has seen that majority judgment was a directive, clear direction was given, and the minorities was the conclusion, my lord. So here, when there is a clear direction by the majority, my lord, whether
No, minority judgment is not a conclusion. You are misreading the judgment. It's written in a serial order. So therefore, the majority judgment is in the four part, and in the second part is the minority judgment. It gives its own conclusion.
its own conclusion, but
It does
here-
not. It does not. There is no summing up of the conclusion by a single judge.
and then the language used, my lord, here the direction, my lord, the majority, what is the direction, my lord? May I 191, my lord, paragraph
So
191.
majority is the judgment. Majority does not deal with it, but the minority view deals with that issue.
There is no adverse remark also against this, my lord.
It's not a question of adverse remark. You see, it's a decision of the Supreme Court. Number one, the principal theory on which we are following is that under 142 judgment of the Supreme Court is binding on
Binding.
141. It is binding on us. Now it doesn't say that the judgment of the Supreme Court, when it is rendered by 2 or 3 opinion, then opinion 1 will be binding and opinion 2 will not be binding. There's no theory like that.
Yes, and in this case, my lord, we have to come back to our own High Court judgment, my lord, division bench judgment and the full bench judgment, my lord. And in these years, my lord, how we have dealt with the issue by this minority judgment.
It doesn't take us anywhere because there's a theory of prospective overruling. All judgments which are prior to that remains. It has attained finality, so those are not overturned. Those remain. People who have got benefit of the old judgment will get that benefit. But from that date, the
My
opinion will be that which is the law, and we'll have to follow what is the law for the time being.
here, my lord, my
Consider.
yes, my lord. On the last submission, my lord, I wanted to recall the wise word of Mr. Marshall when I was a student in attorney, my lord. He used to say that when we are dealing with citizenship matters, my lord, you have to start saying, my lords, that it's a matter of citizenship, my lord, and you have to conclude with saying, my lord, it's a matter of citizenship. With utmost respect and deference to this court, my lord, I'm also repeating the same, my lord, I'm dealing with citizenship matter, my lord. My respectful prayer will be to consider in that
No,
line.
definitely, we know the seriousness. That is why 2 judges. You see, we'll tell you why. Why I have given that statement about the 2 judges taking up these matters. You see, under this Guwahati High Court rules,
My lord.
we are in a very good situation where the author himself is present here. Now, in this, you look at page 398 of this Guwahati High Court rules, and I'll give you here page 395 and 396 is the form. We'll show it to you. P95. You see the superintending jurisdiction. Correct?
Yes, ma'am.
Now 396. Foreigners tribunal is included. Serial number 3 or 4, 2 or 3. No, 396. 396.
Tribunal is also included.
Next page, next page. List of tribunals are there. Foreigners tribunal, you got it?
Foreigner tribunal 5, ma'am.
5, huh? So you see, if it's a superintending jurisdiction and the foreigners tribunal is included in the schedule, 226 matter is taken up by a single judge. But here we are having a departure, we are taking it by a division bench. So therefore, we are aware of the seriousness. Don't worry about that.
I'm deeply obliged, my lord.
We'll consider till pass orders.
My lord.
We are reserving it. It will take some time.
My lord, if my lord is reserving the order, my lord, or my lord will hear the.
No, immediately I'll not be able to, because these judgments you have not even provided. Live law, I don't subscribe.
I'm deeply obliged, my lord.
The submissions of Mr. A.S. Tabada, counsel for the petitioner, as well as Mr. J. Pang, the standing counsel for the FT matters is concluded. Ms. P. Barwa, the standing counsel for the Election Commission of India, and Mr. H.K. Hazarika, learned government advocate are present. Next paragraph. The court awaits verdict.
Item 8 for motion.
Yes, please, Lord. My lord, here, my lord, the impugned opinion is at page 84. 84, my lord. And
It's letter record.
Mr. J. Pang, the standing counsel for the FT matters representing respondent number 2, 4, and 5. And Mr. H.K. Hazarika, the government advocate appearing for respondent number 3. And Ms. P. Barwa, the standing counsel for respondent number 6. Opinion is which page?
my lord, at 84.
84.
But this case, my lord, the operative part at page 88. Earlier there was a proceeding, then it was remanded back, then the face order, my lord, that part is at page 80, my lord. But it is
It's 84. Opinion dated 30/7/2024. Passed by so and so and so and so. Declaring the petition to be a foreigner post 25/3/1971 stream. Notice, call for the records. Extra copies within 2 days. Petitioner shall appear before the Superintendent of Police, Border Morigaon, within 10 days. Bill of rupees 5,000.
my
Conditions of default clause. List after 4 weeks on receipt of reports.
Item 9 for motion.
My lord, here, my lord. This is also contested case, my lord.
The date of the opinion,
My lord, at page 99, 7 to 22, my lord. There is some delay, my lord.
there's a delay. Then protection will give you after receipt or records.
My lord, my lord.
Heard. Mr. A.R. Sigdal and counsel for the petition. Mr. J. Pang, standing counsel for the FT matters representing respondent number 2, 4, and 6. Ms. P. Barwa for respondent number 3, and Mr. H.K. Hazarika, government advocate, appearing for respondent number 5. Mr. Sigdal, your opinion is at which page?
My lord, at page 91.
That's it. You've given many dates in second week of January.
My lord,
Then there is a
that's
Bihu
applicable,
vacation.
my lord.
You vacation.
My lord.
We'll be in some trouble for a few days.
My lord.
Last year one. Make it 9th of January. No, 9th of January. Prayer for bill shall be considered on receipt of tribunal records. Extra copies within 2 days. Please start of 4 weeks. In the meanwhile, if the petitioner is apprehended, she shall not be deported without order of the court. List on
9/1/24.
124. 5.
My deeply obliged.
Item 10.
Yes, opinion of which date?
27, my lord. There is a delay of 1.5 year. 12/6/2023, my lord.
6.
Otherwise, there are links.
Then we will consider your prayer on for bail after it's not records.
Otherwise, there are linkages are there. my lord.
Maybe we don't say that.
Right.
It's a thumb rule because we have to draw a line somewhere.
There's a lot of
Mr. A.W. Aman, counsel for the petitioner. Ms. P. Barwal, sorry, Mr. H. Kuli, on behalf of Mr. A. Ali, standing counsel for respondent number 2, Mr. J. Pang, standing counsel for FT matters, representing respondent number 3, 5, and 6, and Mr. H.K. Hazarika, government advocate for respondent number 4. Opinion is at which page, Mr. Aman?
27, my lord.
27. Page 27. Opinion dated 12/6/2023, passed by so and so and so and so, declaring the petitioner to be a foreigner of post 25/3/1971 stream. Should notice extra copies within 2 days. Call for the records. Prayer for bail shall be considered on receipt of tribunal records. In the meanwhile, the petitioner is apprehended, he shall sorry, she shall not be deported without order of the court based on 9/1/2025. Grateful.
Supply item 47.
Everything. Yes, because this is an requisition for non-registration of the FIR and also the continuous
For
harassment.
non-registration of FIR.
FIR and also the continuous harassment of the police over the petitioner and a family in a tenancy dispute, Your Lordship. Your Lordship, here the petitioner.
No, just a
saying-
moment, just a moment. Here, there's no statement that you approach the jurisdictional magistrate. If
Yes.
not there, then you are against the principle laid down in Sakiri Vasu.
Lordship, we have mentioned here that we could not invoke that because we are in a speedy remedy because they have already trespassed into the land with the aid of the police personnel, Your Lordship. And they have approached the police as well as the SP, Your Lordship, but none could help him. And now they see is a.
No, you see, where is the document of seeking help?
Your Lordship, the FIR I have annexed here with the Lordship. The FIR is at page 29. He was also being beaten after the affairs, she approached on 6th. 29.
See, the ratio of Sakiri Vasu is very clear. After that, Priyanka Srivastava, that you'll have to exhaust that remedy. Extraordinary remedy under 226 will not be invoked.
But Lordship.
You see,
Yes.
you see, please consider in a different way. If the High Court is issuing a direction to register an FIR, that means the police will be compelled to do so. There may be a case, there may not be a case. So that is why the magistrates are there. The magistrates are duly empowered to do it. After Priyanka Srivastava and this Sakiri Vasu, where is the scope of invoking Article 226? Supreme Court has barred it.
Again, they go for invoking that right, then the police report will be called for, Your Lordship, and they have no now such fate upon the respondents, Your Lordship, because they have approached the police. She has been detained in the police station from 1 PM to night 10 PM without any reason, Your Lordship. The petitioner was there. CCTV footage will also that will be revealed, Your Lordship, and she has also approached the SP. No help was being given to her. It will be time consuming, Your Lordship, and also the
But we
trespass.
don't have an answer to that. We don't have an answer to that. It can only happen when you get the order modified.
Point number 11, I have mentioned that we could not invoke the same. Why we could not invoke the same?
You can't help it. Sakiri Vasu bars it. We have so many orders in that aspect.
In the other case law also, Your Lordship, Mosrak Ali versus State of Assam and Jyotishkar Kakudi, Your Lordship.
What is the citation?
In WPC 1932/24, which is still pending, Your Lordship, and WPC 3220/22. 3220/22 and 1932/2024. These are similar cases where directions were given by the Honorable High Court for registration of the
You
FIR.
have a copy?
I do not have a copy with me, Your Lordship, but these are the pending cases.
Yes, sir. WPC 1932/24, last order. 1932/24. Any order prior to this? No, no, even prior to this, just put it here, we'll tell you which order. Put it up here. See the first order. Just open it up. Just open it up. Just give a printout. We are not unable to read it. Doesn't help you because in this case, the party opposed the Superintendent of Police.
Here also she has opposed on 10.
But we don't have anything.
We have mentioned in the petition.
Mentioning is not enough. When we are going, when you are asking us to go against the Supreme Court judgment, we'll have something more. If the magistrate is now prohibited to exercise power under 156(3), unless it is satisfied that the party had approached the police and then approached the Superintendent of Police. You know how Sakari Vasu has dealt on this issue. I am reading para 25. We have elaborated on the above matter because we often find that when somebody has a grievance that his FIR has not been registered at the police station and or proper investigation is not being done by the police, he rushes to the High Court to file a writ petition or a petition under 482 CRPC. We are of the opinion that the High Court should not encourage this practice and should ordinarily refuse to interfere in such matters and delegate to petitioner to his alternate remedy, firstly under section 154(3) and section 36 CRPC before the concerned police officers, and if that is of no avail, by approaching the concerned magistrate under 156(3). That is the language. We have to close this matter. You avail your remedy as available as.
If a lordship can give some direction. then we should whatever
So there's no direction. We only have to close it. We can't give a direction in the matter which we are closing. Because if I give you a direction, then there is no point dismissing it. We'll have entertained it. You think independently, not as a counsel in this brief, but you think you receive a brief of a respondent who says that the court has dismissed it but has passed this order. Then how do you deal with it? Where is your remedy after division bench order? Where is your remedy? Supreme Court. Just turn around, there's a senior counsel sitting behind you, ask the fees which may have to be paid. So we are closing it, we are not passing any order. Heard Mr.
Yes, Ahmed.
S.
Ahmed.
Ahmed, and counsel for the petitioner. Instruct by this writ petition filed by invoking Article 226 and 227 of the Constitution of India. The petitioner is praying for a mandamus against the Superintendent of Police, Nagaon, or the officer in charge, Nagaon Sadar Police Station, and the inspector in charge of Itachali Police Outpost, respondent numbers 2, 3, and 4 herein, not to interfere in tenancy dispute and to register a case filed by the petitioner and other ancillary reliefs. Next paragraph. Mr. Nath, we have not heard you admit this case.
Malad, I seriously object to this case because the FIR itself and the medical documents he has annexed, so many allegations have been made in the writ petition, but the FIR, contents of the FIR, although.
No, we only want to know that you don't support him or you support him.
No, absolutely not, Malad, absolutely not, because this law laid down in the Sakari versus case, Malad already expressed law. It is very clear, Malad, under 156, 156(3), they have the remedy, and under the BNSS also 173(3), the same provision, similar provision is there, Malad. They have to approach the SP and the other authorities first.
Okay. Also heard.
And
Mr.
page number
D.
31. Page number 31, this is the report, discharge certificate. Diagnosis, kindly see diagnosis.
I have seen that.
The FIR says that Malad, so many things have been said in the FIR. Nothing is there.
No. Mr. Dinak, senior government advocate, appearing for
1 to 4.
respondent numbers 1 to 4. Next part. The case projected by the petitioner is that she's a tenant under the respondent number 5 and 6 on the strength of a tenancy agreement, but on
So 5 and 6.
8/12/2024,
Tenant.
in the at about 9 p.m. The daughter-in-law of the petitioner was asked to produce the petitioner before the Itachali police outpost on next date. Post op. It is projected that the petitioner has some mental health issues and she was in the Nagaon Medical College and Hospital and she had to take a discharge from the hospital to appear before the Itachali outpost, where she was unlawfully detained from 1 p.m. to 9 p.m. and mentally harassed. It is also projected that the respondent numbers 5 and 6, with the help of musclemen, had disconnected the electricity supply and by breaking the gate of the rented house started unauthorized construction. It is projected that the attempt of the respondent numbers 5 and 6 was to evict the petitioner without following due process of law and without refunding the security deposit. Post op. Next part, it is projected that because of illegal trespass and illegal detention of the petitioner in the police station from 1 p.m. to 9 p.m. on 9/12/2024, she approached the Itachali outpost for filing an FIR, which was not accepted. It is stated in paragraph 11 of this writ petition that the petitioner did not invoke the provision of section 175 within bracket 3 of BNSS, 2023, as the petitioner desires a speedy remedy and because there is continuous interference of the police authority and illegal trespass, and availing of such remedy would cause further delay. By next para, by referring to the case of Lalita Kumari versus State of Uttar Pradesh, within bracket 2014, bracket close 2 SCC 1, it is submitted that it is incumbent on part of the police to register all FIR and to proceed with the investigation. And in this regard, reliance is also placed on the case of Lalan, LALLAN, Chaudhary, CHOUDHARY, and others versus State of Bihar and others, AIR 2006, SC 3376. Accordingly, this present petition has been filed. Next paragraph. The learned senior government advocate has opposed the admission of this writ petition in light of the decision of the Supreme Court of India in the case of Sakiri Vasu versus State of Uttar Pradesh, comma, within bracket 2008 bracket close 3 SCC. No, sorry, I'm wrong. 2008 2008 2 SCC 409. Equivalent is that column equivalent to within bracket 2007 bracket close 0 Supreme 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 within bracket SC bracket close 1563. Full stop. On consideration of the materials available on record, comma, it would be appropriate to refer to paragraph 25, 26, and 28. Of the case of Sakiri Vasu within bracket Sutra, bracket closed, comma, as extracted from 2007 within bracket 2007 0 Supreme within bracket SC 1563. Next paragraph. In view of the directions contained in the decision of Supreme, Sakiri Vasu within bracket Supra, the court is disinclined to entertain this writ petition in view of alternative remedy available. Full stop. Accordingly, the petitioner may be well advised as to the manner in which she is desirous of seeking appropriate remedy in connection with her grievances. Full stop. With the aforesaid observations, this writ petition stands closed. At the motion stage, without issuance of notice on the respondents.
Thank
Upgraded item 31 for admission.
Meet with your lordships. One of the petitioner filed the writ petition challenging the promotion of the private respondent number 7 and claiming promotion to the post of junior information officer, and that was, my lord, rejected by the honorable single judge, and that is why the appellant is before lordship. Now, my lord, the grounds on which the petitioner appellant, my lord, assailed the selection and promotion of the private respondent was that, my lord, under the rules, it was not a fiduciary post. And secondly, that the appellant is holding the post of librarian, whereas the private respondent was a translator. And my lord, there, the process of selection is also different. Now, my lord, may I take your lordship to the, my lord, advertisement first, my lord? So these are the rules, my lord. I refer to the rules, although it's an annex, it's
No,
a part
this,
of the report.
just a moment, Mr. Chaudhary, this. This Neelam Saika, the appellant, his respondent number.
My lord, I was the petitioner, one of the two petitioners in the writ petition.
Okay.
He was the petitioner, she was the petitioner number 2. The other petitioner has not preferred the appeal.
Okay. Yes.
May I take your lordship to the advertisement first, my lord? That your lordship will get at page 253. To show that, my lord, the post of librarian and post of translator, my lord, the initial selection process itself is different. This is the advertisement, my lord. Your lordship may come to the second call, my lord, second entry, serial number 2. Translator 5, journalist 1, sub-editor come proofreader 1, proofreader 1, librarian 2, missing journalist 1. Now, my lord, the fourth column, your lordship will kindly read, my lord. Educational qualification. Has your lordship got it, my lord? Educational qualification. The minimum educational qualification is bachelor's degree in arts, science, and commerce from any recognized university with minimum 6 months diploma in computer application with typing and in Assamese, typing skill in Assamese. Other essential qualifications, a candidate must be capable of translating any matter from Assamese to English and vice versa in chaste language and must have good command over the English language. This is, my lord, so far as the post of translator is concerned. Thereafter, your lordship will kindly read, my lord. Librarian. Educational qualification. The minimum educational qualification is bachelor degree in library science or graduate in any discipline with PG diploma in library science from any recognized university. Other qualification, adequate knowledge of latest software package and computer application in library management, DTP, and internet. So, my lord, the essential qualification for the two posts are different. Now, if your lordship kindly takes up the rules are a part of the, my lord, appeal, but for your lordship's convenience, my lord, I have given extra copies. Promotion, your lordship will find at, my lord, rule 11, internal page 9. One, my lord, vacancies in the petition, has your lordship got in mind? Vacancies in the cadre of additional director, we're not concerned. Then 2, subject to suitability as may be decided by the commission as set forth in Rule 12 and also subject to possession of qualification and experience as prescribed hereinafter, and officers shall be eligible for promotion from one cadre to another cadre of service in the manner provided below. Now, the relevant provision is, my lord, sub rule Roman 5.
Just a moment. That page 253 you read was first part is the translator.
Yes, my lord.
Second part is that for the librarian.
Library.
Okay.
Private respondent is a, my lord, translator, and the appellant is a librarian. The educational qualification requirement is, my lord, different, and the selection is also, my lord, different.
Yes.
Now, my lord, I was referring to Rule 11, Sub-Rule 11(2) Roman 5. We are concerned with the promotion to the post of Junior Information Officer. So, my lord, Sub-Rule Roman 5 says, from journalist, sub-editor, come proofreader, and librarian to Junior Information Officer.
Let's take it now. Oh,
My lord, is there
this is not available in messages.
I am sorry, my lord, but it's a part of the
No, it's
record
okay.
also, my lord.
Page 10 is not here.
I'm so
No, it's
sorry.
okay. It's okay. So this is promotion to the cadre of
A Junior Information Officer.
Junior Information Officer.
My lord. And Sub-Rule Roman 5 makes it clear that, my lord, the feeder category is from journalist, sub-editor, come proofreader, and librarian. Translator is not included, my lord, in the feeder category.
It was. Yes.
Therefore, my lord, primarily on this ground, my lord, the appointment of a promotion of the private respondent was challenged. And in fact, my lord, the class and cadre status, your lordship finds at Rule 3, page 2, my lord. The service cell consists of the following classes and cadres. Then your lordship may come to small d, class 3. It shall consist of the cadre of Junior Information Officer, which shall include assistant editor, publication, assistant publicity officer, press so and so, so and so. Now, my lord, this is the, my lord, the promotional cadre. And librarian is, my lord, not stated in the feeder cadre. Now, my lord, the Honorable Single Judge has held that librarian has been ungathered. On two grounds, my lord, the writ petition was dismissed. Firstly, holding that the post of librarian was ungathered, and secondly, that it is a past practice that librarians are, the translators are, my lord, promoted as Junior Information Officer. These are two findings which are, my lord. So far as the first finding is concerned, my lord, that it has been ungathered, this is absolutely, my lord, a wrong finding. Now, to bring home that point, my lord, may I take your lordship to the impugned judgment? Impugned judgment starts at page 289. What the Honorable Single Judge did was that.
Just a moment.
My lord.
This, you are referring to the cadre to project that this translators and librarians.
My lord.
Out of these two, the librarians do not form a part of the cadre.
Yes, my lord. That is from, my lord, Sub-Rule 5 of Rule 11. Sub-Rule, my lord, 2(5), 2 Roman 5. Rule 11 starts at page 9. The sub-Roman 5, 2(5) is, my lord, page 10. From journalist, sub-editor, come proofreader, and librarian to Junior Information Officer. So, my lord, the translators do not have this promotional avenue.
Yes.
Now, my lord, may I take your lordship to the impugned judgment, which starts at page 289. Now, so far as the finding of the honorable single judge that translators are included in the gather, your lordship may kindly read my lord paragraph 39. It is at my lord page 316.
360,
316.
316.
Paragraph 39.
Somewhere in the affidavit, a stand is taken
My lord.
to the effect that there was already a draft gradation rules, draft gradation list, and that was never challenged.
Yes. Yes, that ground has been taken, my lord.
Yeah.
But then, my lord, from the amendments in the affidavit in opposition, it is very clear that, my lord, the translators were never, my lord, included in the gather, and my lord, it is only that, my lord, there were some proposals. The proposals have been taken by the honorable single judge as having been approved, which is my lord, actually my lord, wrong finding. I'll draw your attention to that, my lord, those communications which are part of the judgment.
Okay.
In the present case, may I read it, my lord? In the present case, it appears that the 1986 rule clearly provides the power of the state respondents to include any post or cadre along with the federal post prescribed under the said rules.
Just a moment.
Right.
Mr. Chaudhary,
My lord.
we have a difficulty today because there is a single bench where my sister is taking up the bail matters.
Yes,
So can we continue it on Monday? You make a mention, we'll upgrade and take it up.
my lord. I'll make a mention in the morning.
Look, if I'm allowed to make a submission, but this writ appeal has come for admission today. Remember, if lordship admits and we are appearing for the respondents, private respondents are also there. That admission may be done if.
Okay.
That can be done, my lord. I have only one query why I made this, my lord, the upgrading mention because of the fact that, my lord, that post, which, my lord, the petitioners were claiming, my lord, that was kept vacant, my lord, during the continuance of the writ petition. If that is, my lord, filled up, at least one post should be kept vacant, my lord. That will not affect the private respondent. It was vacant, my lord, also. That is the only prayer.
But I have an objection to that, madam, because my information is that no interim order was there at that point of time. No interim order was there at that point of time.
No, that was there, my lord. I am pleased the copy, my lord. Copy of the order. It was there also.
No, Mr. Chaudhary is holding the brief, we'll know more.
Lord,
You're not disputing that.
Lord.
And, my lord, why
this-
urgency has come, my lord? These, my lord, it has been hailed that, my lord, the amendment has been made and the, my lord, my lord, the post has been uncovered. But at the same time, now, my lord, they are, my lord, holding a meeting for verification of the draft.
We do one thing because of our inability to continue today. We are saying that this there will be an interim order till Monday. On Monday, the interim order will be revisited.
My lord.
Or can it be my lord, can the notice be made returnable in a short time, my lord? I'll take the instruction by that time, my lord, because my lord, the
No, it's
promotion.
only because of the interim order we are giving. He's expressing an urgency, but since we are compelled to adjourn the matter today, an interim order, we were thinking to have it till Monday. Because if we are extending it, we are fixing it some other day, then obviously the interim order also stands extended till then. Not to fill up the one post shall be kept vacant.
Then, my lord, let it come on Monday. Lordship may consider on that day. By that time, I'll say at least what if my lord, if the judgment was passed on 21st of 21/11. What has happened? In the meantime, by telephonic, I'll take the instruction. If nothing has happened, accordingly informed. Lordship may take up the matter on Monday. No order may be passed on today.
Okay.
Otherwise, the honorable court has passed a judgment, and our affidavit stand in the affidavit is also clear. At page 112, stand is there. We have also taken the stand that the posts are similar, they are equivalent posts, and that has been accepted by the honorable court. Then
No, equivalent of encadreds will be different. If it is an equivalent
there are
and not encadred, then you are selling against the tide.
there are executive instructions. The two instructions are there. Honorable court has accepted those and accordingly said that that has been the impugn notification has been upheld.
I'll point out, my lord,
Lord,
that it is
on-
those two communications are only proposal.
On Monday,
Only proposal for encadrement, and my lord, that has not been, my
No,
lord.
just a moment. This Assam Information and Public Relations Service rules. It is under 309.
309 rules.
Then you don't know the position.
Rule permits, my lord. Page 165. I'll take your lordship on Monday. My lord, I'll take your lordship.
165.
Lordship.
Just a moment, because
Lordship.
something interesting. Page number?
Page number. No. It is wrong. Take it. Well, page 139. Kindly come to
39.
139. Is the rule. This is not the power of the government to engather, my lord. The service may also include, I'm just referring to the relevant portion. The service may also include any post equivalent to a post in any of the cadres mentioned in sub-rule 1. And any cadre or post laid down by the government to include in a cadre of the service.
That has not been done, my lord. I will show, my lord. Only there is a proposal, there are two proposals, and proposals have been accepted by the honorable single judge as my lord approved.
Okay, then we'll take it on Monday.
On Monday, lordship, we take up one. Lordship.
Till that time, your lordship will.
If any post is not filled up as on today,
It has not.
Well, today is Friday, tomorrow and the day after tomorrow is a holiday. Nothing will happen. Nothing will happen on Monday.
no, we don't know.
And my lord, keeping the post in any case, otherwise also keeping the post will not benefit anybody. On Monday, lordship is taking.
Your lordship.
I'll in the meantime, I'll get the information.
Prayer for my lord, the early, my lord, order, because of the fact that, my lord, they are holding a meeting for amendment of the rules. In the meantime, they may amend, and my lord, private respondent number
Amendment
7
can be
is,
stopped.
my lord.
Amendment if happened can't be stopped.
It cannot be stopped, my lord. I am not asking for that, my lord. That is why, my lord, the urgency is there, my lord.
We understand, but
And respondent number 7, my lord, she is a part of the this committee, my lord.
huh?
Respondent number 7. Her name is Musumi Bhattacharya. Her name appears at the, my lord, the last name in the committee, my lord.
Okay. Mr. Nath, as on today, we are passing an order. We are not saying it till yesterday, but today, if it is not passed, let it not be passed. Because otherwise, what happens is that we record your submission and then something more happens. We don't want that. Observe the court, we don't want to question.
Lots.
Heard Mr. MP Chaudhary, Learned Senior Counsel, assisted by Mr. A. Fugan, Learned Counsel for the petitioning. Also heard Mr. D. Nath, Learned Senior Government Advocate, appearing for respondent numbers
1 to 5, my lord.
1 to 5.
I am for 6, lordship.
And Mr. P. P. Datta, Learned Standing Counsel for respondent number 6. So due to positive time, the matter could not be taken up today. Would be positive time. The submissions of the learned senior counsel for the appellant could not be concluded. Full stop. Just make it differently. Order would be that. Sir, heard Mr. MP Choudhury, his submission remains inconclusive. Mr. D. Nath and Mr. P. Datta are present. Persons are present. Next para. As the issue relates to the claim of promotion to the post of junior information officer, court is inclined to provide that in the event the promotions have not been given effective till proposed promotions to the post of junior information officer, if not given to till 3:30 PM on 13/12/2024, shall not be given effective till matters next taken up on 16/12/2024. Next para. List on 16/12/2024. Next para. The instructing counsel for the appellant is granted liberty to pay for upgrading the matter.
Yeah, bless man.
You are giving, have to give precedence to Article 21.